Hi guys, it's Kathy. My camera just turned off just right now, but that's okay. It'll turn back on again in a second when it wants to. Hi guys. We made it to Thursday. Kelly, thank you so much. I got a box of pecans yesterday, and I'm going to make a pecan pie for Thanksgiving. Very excited about it. Very excited about pecan pie. It's very good. All right. We're going to go to here today. We're going to go to Judge Claymore in Indiana. Maybe we'll get to see Bobby today in handcuffs. Bobby, what did you do? No, we'll never see Bobby in jail. Desperately looking for the play button. There we go.
It's a vain we.
Save me some. Save
Are we
pumpkin
doing this
pie.
by phone or by
Pecan
video?
pie.
Doing it by
That's-
phone. All right.
No, you could have some pumpkin pie. It's hard to save pecan pie.
Savane Lee, can you hear us? All right. We're going to try to call.
Sure.
Thank you for calling the Pattonville Correctional Facility. Our normal business hours are Monday through Friday, 7 a.m. to 3 p.m. Central Standard Time. If you know the four-digit extension of the person you would like to reach, please dial it now.
Okay.
Somebody?
Hi, this is Judge Clymer in Porter County, and we have a hearing set with Savane Lee.
Okay, hang on just a second.
All right. Is this Mr. Lee? This is Judge Clymer. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? What is your name? How old are you?
34.
Did you complete rehabilitation while incarcerated? What'd you learn?
Learned that think over and the whole bigger picture at hand, that my sobriety is very important to me. And in order to be successful, I have to stay
Well,
and I've learned how to manage.
I promise this is the only part right here where the sound is a little yucky because they're on the phone. But you get to hear him a little better soon. And this isn't that long, this guy. I will definitely take a picture of the pie before we eat it all.
My triggers as well.
trigger's not a good thing to say in court, but it's good to say you need to stay sober. Anybody can say that. What'd you learn about staying sober?
But where things in life is just better. I'm able to go in office.
When is your expected out date? Earliest possible release date? And you asked that I get a progress report from the DOC, and you had some conduct issues early on. Is that right? What happened so that you've stopped having conduct issues, or what happened that you've actually started to behave in the DOC?
Hurt. So sometimes, like you said, you can say a lot of things, but when you really want to do something different, it starts with yourself. And it's like something, a light bulb, and something just went off in me, and this was like, I had to do different. Because looking around, being in a place like this, it's like, I can't do this. I can't. So it went off in me, and it just like from that moment on, I don't know if it was God, I don't know what it was, but just from that moment on, everything just changed for me. Like I can't explain it. I don't know what it was, but it happened, and I'm grateful that it happened because since then, like I said, I've trouble. It hasn't happened as of yesterday. It's funny, like timing is so amazing because yesterday I went and saw my caseworker. I signed my level 1 papers. It's just from going from a level 4 maximum facility to where I am now to now signing level 1. It's just like it's like it's all happening. It's all happening, and I believe that it's just something went off and it just changed.
Pavlovsky, do you have any questions for Mr. Lee?
No questions, Your Honor.
So, Mr. Lee, tell me why I should modify your sentence.
Really believe in my heart that it is time for me to exercise everything I've learned in society, not only for myself but for my 9 children. I also believe that if not no time, now is the best time because I have to at some point show the things that I've learned, and I have to pay it forward to stop those and potential of coming where I am to help from my experiences to be able to teach and continue to grow.
Mr. Pavlovsky, what's the state's position regarding modification of Mr. Lee's sentence?
Your Honor, I see in the plea that was negotiated back in late 22 that Deputy Hammer did indicate that the defendant, after serving 2 actual years of incarceration, entered the recovery while incarcerated program. He could petition for modification. However, looking at his criminal history, it appears that earlier this year he was sentenced to a term of 4 years for level 5 trafficking to an inmate inside the DOC. So I think that substantially violates the spirit of what was intended in the plea agreement. Based on, I understand he's taken classes and has worked on the things he's talked about, but I can't in good conscience agree to a modification with a felony conviction within the DOC that this recently.
When was that?
He was sentenced February 17th of this year.
So the sentencing order that I did in December of 2022 indicated that the sentence in this matter was to run consecutive with the 71 DO2 2103. That's not the sentence that we're talking about. You're talking about a February of 2025?
This is cause number 67 CO1 2404 F5 12. And it looks like the sentence is 4 years consecutive to the case we're currently here on 3183.
Go ahead, Mr. Lee. That was a 4-year consecutive probation sentence.
It just says confinement 4 years, Indiana DOC. I don't have any, he might be correct that it's probationary.
Based on the earliest possible release date from the DOC.
Makes sense.
Well, that's a concern that the court was not aware of. It appears, though, that the sentencing judge who would have been aware of that believed that an appropriate sentence would have been a 4-year suspended sentence. The sentence that I entered in December of 2022 says that after successful completion of the RWI program, the defendant may petition to modify, and the state has a right to oppose. The state has stated its opposition based upon
He's pondering. Judges do that sometimes.
the successful completion. However, the court was unaware of the sentencing order, which was entered on February 17, 2025. In that matter, and caused 67 CO1 2404 F5 12. The defendant was sentenced to 4 years in the Department of Correction with 2 years executed and 2 years suspended to probation. So it's a 2-year executed sentence. That executed sentence begins to run at the completion of the sentence in this case. At this point, I deny the motion to modify based upon the conspiracy to commit trafficking with an inmate that was filed in April of 2024. However, that denial is without prejudice. I'm setting this matter for a status in 3 months to see whether or not the defendant's behavior is modified. At this point, it's denied without prejudice. This matter is set for a status February 4th at 9 o'clock Valpo time, 10 o'clock Putnamville, and we'll coordinate that with the DOC. Are you okay with that in the DOC? Did you hear?
Yes.
All right. So the request to modify is denied based on the new charge that was filed. It'll be reheard in February. February 4th at 9 o'clock. That will be all.
Going back to the Porter County Jail, state calls Tyler Hippen. This is State of Indiana versus Hippen, cause number 64D02 2511 F6 12809. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail with Attorney Ken Elwood, who appears in person for the limited purpose of initial hearing.
Will you raise your right hand, please? Other right. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
What is your name?
Tyler Hippen,
How old are you?
28.
Do you understand English?
Yes,
Are you under the influence of any drug or alcohol?
no,
Do you have any mental or emotional disability?
no,
If there's ever a time where you can't hear or understand anything at all for any reason, will you let me know?
yes,
The prosecutor is going to advise you of the charge that has been filed against you and the potential penalty if you're convicted of that charge. So please listen carefully.
State of Indiana is charging the defendant, Tyler Joseph Hippen, with 1 count of dealing marijuana, level 6 felony. Charge reads as follows. Officer Smith of the Portage Police Department swears on the penalty of perjury that on or about November 17th, 2025, in Porter County, Indiana, Tyler Joseph Hippen did knowingly or intentionally possess with the intent to deliver marijuana, pure or adulterated, classified in Schedule 1, with the said marijuana, hashish oil, or salvia weighing more than 30 grams but less than 10 pounds, contrary to Indiana code and against the peace and dignity of the state of Indiana. A level 6 felony is punishable by 6 months to 2.5 years in the Indiana Department of Corrections.
Mr. Hippen, do you understand what the allegations are against you?
yes,
Do you understand the potential penalty if you're convicted of that allegation?
yes,
And you were present when I advised the earlier defendants of their constitutional rights. Is that correct?
yes,
You understand that the rights that apply to him also apply to you.
yes,
I'm entering a not guilty plea for you, reserving your right to a jury trial and ordering the state to produce discovery to you or your attorney. We're now going to address bond. Prosecutor goes first.
Your Honor, in the pretrial service report, the defendant scored a 2 low, no FTAs in the past 2 years. I would note that he resides outside the state of Indiana. Appears he has an Iowa address. Looking at his NCIC, there does appear to be some sort of, it says controlled substance violation, conspire with intent to deliver marijuana out of Washington County District Court in Iowa. So it does appear he has a similar related prior based on the criminal history and the fact that he poses a flight risk residing out of state. I would ask for a cash bond of $1,500.
Mr. Elwood.
Mr. Hippen, can you afford $1,500?
I cannot, no. I'm not even from here. I live in Iowa. I don't even have my wallet. They took it in my car, so.
Judge, he scores a 2, no FTAs in the last 2 years. While there obviously is some concern that he lives in Iowa, he has no history of failing to appear. I would ask for OR release supervision level 1, which is the recommendation.
Mr. Hippen, do you have any people that could help you post bond?
I do not, sir. I already asked.
The risk assessment scores you a 2, which is just about as low as you can get, and it also has a recommendation that you be released on your own recognizance. I am going to follow that recommendation. One thing that is of concern of the court is the alleged quantity of marijuana that you possessed while in the state of Indiana. If marijuana is legal in Michigan, you can't drive through Indiana with marijuana in your car. Those are the allegations. And you're presumed not guilty. I am ordering you released on your own recognizance. That means you don't have to pay any money to get out of jail. According to the papers that I have, you actually have a job working 60 hours a week.
I do.
So I assume then working 60 hours a week, you could use that money to hire a lawyer.
Yes, sir.
I am ordering you released on your own recognizance. I'm placing you on pretrial supervision, which means this: you will need to report to probation, which is at 157 Franklin Street in downtown Valparaiso, and meet with the pretrial supervision officer. You will then, because you live in Iowa, need to phone into that officer twice a month. You will not need to come see that officer. Do you understand that?
Yes, I do.
Your first hearing date is January 12th at 10 o'clock for an attorney status conference.
Okay.
The next date is February 9th at 10 o'clock for an omnibus change of plea hearing. March 23rd at 10 o'clock for a final pretrial conference. And jury selection would be April 27th at 1 o'clock. The first hearing on January 12th at 10, you may attend that hearing by Zoom. So you don't have to come back from Iowa, and we have snowstorms sometimes. So you'll be released on your own recognizance, which means pay no money to get out of jail, but you must report to probation before you leave the state of Indiana. Otherwise, I'll issue a warrant for your arrest. Do you understand all that?
Yes, I do.
I will see you January 12th at 10 o'clock, either in person in the courthouse in Valparaiso or by Zoom. I believe the jail has the Zoom contact information. I will see you in January.
Thank you.
Going back to the Department of Corrections, state calls Christopher Marcial. This is cause number 64G02 2410 F5 10111. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Department of Corrections along with Attorney Shargoloff, who appears in person. We are set for status.
Your Honor, good morning. In Mr. Maciel's case, we recently received the plea in writing. Given his current living arrangements, we did send that via regular mail over to him. I'm requesting an additional status date to allow me an opportunity to meet with Mr. Maciel further to discuss the terms offered in the plea.
No objection.
Are there any communication issues with Putnamville?
No. We've been able to speak, Judge. Now that we have something in writing, again, I did send that to Mr. Maciel. Just need time to review it with him.
You can advise your client to not answer this one.
Understood.
I'm going to ask anyway. When's your expected earliest possible release date, Mr. Maciel?
12 or something, 2028.
So time is not incredibly of the essence now. Does the pendency of this matter affect your classification within the DOC?
Also, I have on this case that I'm serving right now on PI, RWI. I finish RWI in about 2 weeks, 3 weeks maybe. And then I go for a mod on this case. If this is going on, I don't know how that's going to work out. But as soon as I'm finished with RWI, they automatically send the modification to my judge in Lake County.
You understand that the judges in Porter County don't really like when you catch new charges even while you complete RWI. You understand that here at least?
So I guess, yes, I do understand that, sir. I apologize, but I didn't, this is all before I got, okay, so I was like in Lake.
Christopher, don't
Right.
talk about the specifics of the case. He is correct, though, Your Honor, regarding the timing. It's an older case. The difficulty has been where he's currently placed. It's a little bit more difficult to get in touch with him than it is to go to Porter County Jail.
So because of the potential RWI modification, that might affect the earliest possible release date.
Correct. So I think if we went 30 days, Your Honor, that should be more than enough time. Again, we already sent the plea out earlier this week. It might have been Monday, and we just need a chance to speak with him.
This matter is set for a status January 7th at 9 o'clock, and we will coordinate that, Mr. Maciel, with Putnamville.
And then I'll talk to you before that, Christopher.
All right, thank you, sir.
See you in January.
Yep, God bless you. Am I good?
Yep, you're good.
Going back to the Porter County Jail, state calls William Allen Davis. This is State of Indiana versus Davis. Cause number 64 DO2 2511 F6 12756. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with Attorney Elwood, who appears in person for the limited purpose of initial hearing.
Okay, raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
What is your name?
William Allen Davis,
How old are you?
78.
78?
Yes, sir.
Do you understand English?
Yes,
Are you under the influence of any drug or alcohol?
no,
And you've heard me advise the earlier defendants of their constitutional rights. Is that correct?
pardon, sir.
All right. I'll advise you of your rights separately. The prosecutor is going to advise you of the charges that have been filed against you and the potential penalties if you're convicted of any of those charges.
Yes,
Mr. Pavlovsky.
Yes, Your Honor. The state of Indiana is charging the defendant with 2 criminal counts. Count 1, residential entry is a level 6 felony. Officer Tinnell of the Porter County Sheriff's Department swears on the penalty of perjury that on or about November 15th, 2025 in Porter County, Indiana, William Davis did knowingly or intentionally break and enter the dwelling of William Pester, contrary to Indiana code and against the peace and dignity of the state of Indiana. A level 6 felony is punishable by 6 months to 2.5 years in the Indiana Department of Corrections. Count 2, battery, a class A misdemeanor. It's alleged that on that same date in Porter County, Indiana, William Davis did knowingly or intentionally touch William Pester in a rude, insolent, or angry manner, which resulted in bodily injury contrary to Indiana code and against the peace and dignity of the state of Indiana. A class A misdemeanor is punishable by 0 to 365 days in the Porter County Jail. Those are the charges.
Mr. Davis, do you understand what the 2 charges are against you?
yes,
Do you understand the penalties if you're convicted of either of those charges?
yes,
You have the following constitutional rights. You have the right to a public and speedy trial. Do you understand that?
yes,
That trial could be conducted in front of 6 jurors or me. Do you understand that?
yes,
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
yes,
You have the right to face and cross-examine every witness. Do you understand that?
yes,
You have the right to have me issue subpoenas, to have witnesses testify for you. Do you understand that?
yes,
You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
yes,
You have the right to an attorney. If you cannot afford one, I will appoint one for you at no charge. Do you understand that?
yes,
I am entering a not guilty plea for you on both counts. You have signed a no contact order while in the jail. Is that right, sir?
yes,
Did you read it before you signed it?
yes,
And you understand that you cannot have any contact in person or by phone or by social media, any contact at all with the protected person. Do you
Yeah.
understand that?
yes,
Also, as a condition of the no contact order, you're not allowed to possess a firearm. Do you understand that?
yes,
Do you understand that if you violate the terms of the no contact order, your bond could be revoked and you could be charged with a new crime? Do you understand that?
yes,
All right. We're now going to address bond, but before we begin, I see that there's a California DOC hold.
Yes, Your Honor.
All right, we're going to address bond.
Looking at the pretrial service report, although he does score 1 low, he does reside out of state. I see a current Tulsa, Oklahoma address. There does appear to be a hold out of California DOC. Looking at the NCIC, I see over 20 different cycles showing a bit of a criminal history. And one of the last cycles, I believe, does indicate some sort of parole violation out of the state of California. I'm assuming, well, I don't have access to the records. That's what the hold is for.
Well, so do you know whether or not it's an extraditable hold?
I do not, Your Honor.
All right, well, we will address bond.
You know, based on the fact that he's out of state, has a hold in a third different state, and has a significant criminal history, from what I can tell, I think some bond is appropriate. I would ask for 2,500 to reflect the flight risk.
Mr. Davis, the next lawyer is going to speak as a lawyer who's here for you for the purpose of bond only. Mr. Elwood.
Judge,
Fine.
scores a 1 low, no FTAs in the last 2 years. There is the concern of the hold and obviously living outside of Indiana. I would ask for $10,000 surety.
are you on? I'd like to plead guilty with an explanation.
I've already entered a not guilty plea for you today. This is a level 6 felony. This isn't a misdemeanor case. You're not allowed to plead guilty today, but let me ask you this. Do you have the money to hire a lawyer?
No,
Would you like me to appoint a lawyer for you at no charge for you?
I don't think I need one, Your Honor.
Well, okay, I set bond for you in the amount of $10,000 cash.
I'll accept an attorney, Your Honor. I will accept the public defender.
You want a public defender now?
I will accept the public defender, Your Honor.
All right, I appoint Attorney Mitch Peters to be your public
Very
defender.
smart.
The jail has contact information for Mr. Peters.
We got a guy coming up who's not so smart.
Do you have any money at all to post as bond?
No,
Nothing?
no, very low.
Well, do you live in Oklahoma?
Yes.
Do you have any connection at all to the state of Indiana?
No, I don't.
Well, I don't know if the,
I grew up here. That's how I grew up in Indiana. That's the only connection I have.
So did Bobby.
but you live in Oklahoma now?
Yes.
Is there any reason at all for you to come back to Indiana other than this case?
No, there's not. Um, this arose because of my love for, uh, Mary Pester, and I see that that's impossible now.
All right, I don't want you to talk about the case. I just wondered what the connection was to Porter County. What I'm going to do at this point is set bond for you in the amount of $10,000 surety, but I'm appointing Attorney Mitch Peters to be your public defender, and we're letting him know that right away. And we're setting this matter for a bond review hearing on Monday, but you'll have a chance to talk to Mr. Peters before the bond review hearing. So there's a bond review hearing November 24th at 9 o'clock. You are also ordered to appear, sir, on the following dates. February 9th at 10 o'clock for an attorney or for an omnibus change of plea hearing. March 23rd at 10 o'clock for a final pretrial conference, and April 27th at 1. But Mr. Peters will be in contact with you. There'll be a bond hearing. Were those Wednesday dates?
Should those be 9 o'clock in September?
9 o'clock on those dates. Mr. Peters will be in contact with you. We'll see you in court on Monday.
Yes, John.
9 o'clock.
That's right next to me. I love Baltimore. I love going to Baltimore. Going out on a boat.
Brett Pullins. This is State of Indiana versus Pullins, cause number 64D02 2510 F5 11683. State by Deputy Prosecutor Pavlovsky. Defendant and defense counsel appear in person for initial hearing.
And we're here for an individual. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is your name?
Brett Florence,
How old are you?
27.
Do you understand English?
Yes, sir.
Are you under the influence of any drug or alcohol?
No,
Do you have any mental or emotional disability?
no.
Mr. Elwood, have you gone over the charges and penalties with your client?
Yes, Judge, we would waive a formal reading. And if you're not guilty.
And Mr. Pollins, you've sat in court today and heard me advise a number of people of their constitutional rights. Is that correct?
Yes, Your Honor.
Do you understand that the rights that apply to those people also apply to you?
Yes, Your Honor.
And you're entitled to a trial of 12 jurors because this is a level 5 felony. Do you understand that?
Yes, Your Honor.
Do you have any question at all about your rights?
No, sir.
And this court does take notice that there was a self-defense notice that was filed on November 7th. Mr. Pollins, you are ordered to appear on the following dates, sir. February 18th at 9 o'clock for an omnibus change of plea hearing. March 25th at 9 o'clock for a final pretrial conference. And April 27th at 1 o'clock for jury selection. Did you hear those dates?
Yes, sir.
But before you leave, you need to sign a no contact order. The court security officer will present that to you.
She is out like a light. She is dead asleep.
And Mr. Pollins, you've signed a no contact order in open court. Is that right?
Yes, sir.
You understand that by signing that, that means you're to have no contact at all with the alleged victim in this matter. Do you understand that? That is in person, by social media, phone, internet, no communication at all. Do you understand that?
Yes, Your Honor.
You understand that if you do, you could be charged with a new crime and your bond could be revoked. Do you understand that?
Yes, Your Honor.
Do you also understand that as a condition of your no contact order, you're not allowed to possess any firearms? Do you understand that?
Yes, Your Honor.
I will see you on February 18th at 9 o'clock, sir.
Thank you, Judge.
Matthew Zarnecki. This is State of Indiana versus Zarnecki, cause numbers 64D02, 2412 F6, 2647, and 2412 F5 13069. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with Attorney Charloff, who appears in person. We are set for status.
That's correct, Your Honor. Mr. Zarnacki's case, we have been unable to reach an agreement for a non-trial disposition. At this time, my client would like to enter a plea of guilty.
You said case.
Wait, what?
Cases.
Wait, what? What did he say? Okay, Judge, we talked to the prosecutor. They're not going to give us any type of deal, so we're pleading guilty to everything.
Cases plural.
Correct.
Enter a plea of guilty in which case or
In
cases?
both F6 12647 along with F5 1306.
I would have no content if this was just this easy all the time. Okay, no deal. Jail.
69.
Mr. Zarnecki, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
What is your name?
Matthew Zarnecki,
Mr. Zarnecki, how old are you?
43.
Do you understand English?
Yes.
You understand everything that's going on right now?
Yes, I do.
And did you just hear Mr. Chargolov say that you would plead guilty in both matters without the benefit of a plea agreement? Do you understand that?
Yes, I do.
And you understand that in the level 5 felony, you have a right to a trial by 12 jurors. In the level 6 felony, you have the right to a trial with 6 jurors. And you also have the right to a bench trial in both of those. Do you understand your rights?
Yes.
You understand that the state in either case or in every case has an obligation to prove beyond a reasonable doubt every element of the charge that's been filed against you. Do you understand that?
Yes, I do.
And it's your intent to plead guilty, what Mr. Chargolev has told me, in both cases. Is that right?
Yes.
So with respect to the level 6, there are 3 separate counts, all being level 6s. And in the level 5, there is 1 burglary count, a level 5.
Correct.
So is it Mr. Zarnecki's intent to plead guilty to each of the counts in the level 6 as well as the only count in the level 5?
Correct.
So let's do this then. Let's start with the level 5 first. Cause number 64D02 2412 F5 13069. Mr. Zarnecki, you understand that the state must prove you guilty in this matter. Do you understand that?
Yes.
Mr. Chargoff?
Your Honor, has he already entered a plea or is the court asking me to establish factual?
Well, Mr. Zarnecki, in cause number 64D02 2412 F5 13069, a level 5 burglary case, how do you plead?
Guilty.
Let's go to the pleas in the level 6 and then there'll be factual basis. Mr. Zarnecki, in cause number 64 DO2 2412 F6 12647, count 1, possession of methamphetamine less than 5 grams, a level 6 felony. How do you plead?
Guilty.
In count 2, possession of a narcotic drug less than 5 grams, a level 6 felony. How do you plead?
Guilty.
In count 3, unlawful possession of a syringe, a level 6 felony. How do you plead?
Guilty.
There are guilty pleas now, and the 3 counts in the level 6 and the only count in the level 5. We need factual bases for each of the counts.
Matthew, let's start with F513069. I'd like to direct your attention back to a time period between November 8th of 2024 and December 6th of 2024. At that time, were you present here in Porter County, Indiana?
Yes.
That time, did you break and enter the building or structure of Blue Cassia?
Yes.
And that was a hotel or motel, correct? Not a residence.
Yes. Correct.
And you entered the premises with the intent to commit a felony or theft in the building, correct?
Yes.
And in fact, you had taken some copper piping, correct?
Yes.
And again, this all occurred within Porter County, state of Indiana.
Correct.
Nothing further as it relates to F513069. Defense would stipulate to the probable cause affidavit as a further factual basis.
State will stipulate.
Jude, thank you
So
so
in
much. Thank you,
13069,
thank you.
there is a guilty plea after advisement of rights, and there's also a factual basis as well as a stipulated factual basis. You may proceed to level 6.
Thank you. Matthew, let's talk about F612647. I'd like to direct your attention back to December 7th of 2024. At that time, were you present here in Porter County, Indiana?
Yes.
And you had an interaction with law enforcement, correct?
Yes.
And at that time, you had in your possession a syringe, correct?
Correct.
And you did not have a prescription or a valid reason to possess that syringe, correct?
No.
In fact, you possessed that syringe with the intent to introduce a controlled substance into your body, correct?
Correct.
And at that same time, at the same interaction, you also had in your possession fentanyl, correct?
Yes.
And you knew the substance to be fentanyl, correct?
Yes.
And you did not have a valid prescription to possess the fentanyl, correct?
No. Yeah. No, I didn't.
And also on that particular date, you had in your possession methamphetamine, correct?
Yes.
And again, you did not have a valid prescription to possess the methamphetamine, correct?
Correct.
And you knew the substance to be methamphetamine, correct?
Correct.
Nothing further, Your Honor. Defense would stipulate to the probable cause affidavit in F612647 as a further factual basis.
State will stipulate.
The court finds that there's been an advisement of rights. The defendant is knowingly, one advisement that I didn't do, not expecting the plea, was, Mr. Zarnecki, you have a right to be transported to court to plead guilty in person, as well as to be seen by video from the jail. And you agree to waive your right to be transported to the courtroom. Is that right?
Yes.
As it relates to the change of plea hearing, we would request the transport for sentencing, please, Your Honor.
The court would have done that sua sponte, given the fact that it's a change of plea without an agreement. The court would have done that on its own motion. When should we have sentencing, Mr. Chartloff?
Judge, we would like to use 30-day, please.
Which gets us to December 17th, I believe, would be the week after the prosecutor's conference.
That's fine.
This matter is now set for sentencing December 17th at 10 o'clock.
Would 11 be easier? for the
11
court
o'clock
To
would
allow
be
transport?
Better, and the court will have Mr. Zarnecki transported in person for sentencing December 17th at 11 o'clock. Mr. Zarnecki, please cooperate with probation regarding a pre-sentence investigation report. I will see you December 17th at 11 o'clock in person, sir.
Thank you, Judge.
Thank you.
Robert Davenport. This is State of Indiana versus Davenport, cause number 64 DO2 2012 F3 9805, state by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with Attorney Shargloff, who appears in person. We are set for status.
Correct, Your Honor. In Mr. Davenport's case, there has been a written plea offer tendered. He'd like some time to review that, please. I'd ask the court for one additional status. About 2 weeks would be fine, whatever regarding the congestion with the holiday calendar, Judge, sometime in December.
Takes us to the 3rd in reality because the 10th is prosecutor's conference.
Yes.
All right.
That should be sufficient time.
Defendant's motion to continue is granted and the defendant is accepting Rule 4 time, correct, Mr.
Correct.
Douglas? Defendant's motion to continue is granted. This matter is set for a status December 3rd at 10 o'clock. We'll see you then, Mr. Davenport.
Yes, sir.
Henry Huff.
Don't forget the Eaton. They were eating
This
too.
is State of Indiana versus Huff, cause numbers 64 DO2, 2509 F5, 10159, and 2504 F6, 4424. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with Attorney Shargloff, who appears in person. We are set for omnibus.
Could I have just one moment, please, Judge?
May. Hit the mute button.
That's a healthy reaction, Jude.
Judge, in Mr. Huff's matter, there has been a written plea agreement that has been tendered. Mr. Huff is taking some additional time to review that. Additionally, in F6 4424, I believe we have the alleged victim present via Zoom, and we would like to address the no contact order currently in place, please.
So is the alleged victim in Mr. Huff's domestic battery case present by Zoom?
Yes, Your Honor.
What is your name?
Heather Maldonado.
All right, please raise your right hand.
No crap. I gotta switch hands. Okay.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
What is your name?
Heather Maldonado.
Mr. Chargloff.
Ms. Maldonado, could you spell your last name for our court reporter, please?
Yes, it's Maldonado.
And Ms. Maldonado, you are the alleged victim in F6 4424, correct?
Yes, sir.
All right, and there's currently an active no contact order between you and Mr. Huff, correct?
Yes, that is correct.
Okay, and is it your desire that that no contact order remain in place at this time?
No, actually, I would like to have that order removed. I've called the prosecutor and I've set up a couple classes, but with my work schedule, it's been hard. Me and Henry we've never really argued. We've been engaged for 3 years. This is probably a one-time thing, and although we probably will not ever be together again, I do possess all of his belongings here in my home, including a vehicle and expensive items. And if he does get released or when he does get out, I would like him to be able to comfortably come and to remove his items. I don't see him as any kind of a threat. I've known him since I was a child.
I have no further questions.
I don't have any questions either.
Well, I do. So
Okay.
is Ms. Maldonado is in reality, what I heard you say is you don't think you really have a relationship with Mr. Huff going forward, but you have some of his belongings.
I
Would
have
you
all
like-
of his belongings, Your Honor.
Okay.
From clothes to tools to radios to a TV to our bed to his vehicle. He has a truck here. I have all of his belongings, yes. And they are being maintained and I will not, they're here waiting for him.
So what we have done as recently as 2 days ago is modify the order or allow police to be present while personal property is removed. But at this point, Mr. Huff is in jail.
That's correct,
His-
Your Honor. Well, hold on, Ms. Maldonado.
Yeah.
That doesn't lead to any other questions. Given my understanding of the terms of the plea, which I'm fairly positive we are going to submit to the court, I would just suggest that that might not be the most efficient use of the court's order because it's an executed sentence, Judge.
So then what's the best way to allow Mr. Huff to retrieve his property?
I would suggest that the court terminate the NCO today. That way, once the plea is submitted, it would have to legally anyway be terminated because it's a completely executed sentence. So upon the completion of his sentence, which we're pushing towards, the NCO can't stand anymore. So at this point in time, I think there is still a fair slight protection to the alleged victim in that Mr. Huff will not be released. He'd only be able to contact her via phone. So it's just setting up some logistical arrangements for the return of his property upon his release, Judge. But I think the evidence that Ms. Maldonado has presented to the court today indicates that she's not in fear. She has set up the classes at the prosecutor's office, but she's just been prohibited from attending them given her work schedule at present.
That was going to be my exact comment. I mean, the NCO would terminate upon his release based on the sentence being served at that point. He's obviously not any physical threat to her while he's in the jail. If they want to communicate in order to coordinate the return of property, as Attorney Sharloff said, I think that's
While he's in custody.
while he's in custody. But it would be terminated once he gets released anyway.
So here's then, I think what I just heard the state say is the state has no objection to terminating the no contact order.
Given the plea agreement that he's indicating is going to accept in a future date, yes.
The defendant's request to terminate the no contact order is granted. The no contact order between Mr. Huff and Ms. Maldonado is now terminated. Communications can certainly be had regarding returning of Mr. Huff's personal property.
Thank you, Judge.
How far out then should we go to?
We're set.
Moving forward.
My apologies. We're set for an omnibus. So if we could get roll to the pretrial, which I
Kelly. Hi,
believe is
DC.
set for. That works, Judge.
All omnibus issues are rolled to the previously scheduled pretrial conference. Mr. Huff, you may communicate with Ms. Maldonado regarding return of your personal property.
Thank you, Your Honor.
Luke Romer. This is State of Indiana versus Romer. Cause number 64D02 2210 F5 8301. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with Attorney Sharloff, who appears in person for status.
That's correct, Judge. We're here today for a credit day computation. Based on my review, the court had originally sentenced Mr. Romer and given him 6 days of credit back in the original sentencing order. I believe the amended sentencing order also reflects those same 6 days. Once the first petition for revocation was filed, he was in custody. The court imposed the 20-day stayed sentence. So he served 15 actual days from February 9th of 2024 to February 24th of 2024. And then from May 10th of 2025 up until today, that is 194 days.
It looks like the sentence that I imposed in October of this year said 270 actual days. The word actual is written into the recommendation.
Correct.
And how many credit days are there based upon your calculations?
If the court includes the 6th, Judge, then we would be at 215 actual days as of today.
how does the state calculate the days? So in reality, it's 55 more actual days is what you're saying to the court?
Correct.
Your Honor, frankly, I was not aware that the credit time was at issue today. I don't have a calculation for the court.
And we knew, Judge, to be fair, we knew that Mr. Romer was in custody from May 10th of this year. He had brought up at the last time, and I do believe he's correct, in as far as it relates to the February 9th, 2024 date up until February 24th of 2024. That's post imposition of the sentence and judgment of conviction. Since we're at an ultimate disposition, my understanding is that he does get credit for those days. The part in question is the 6 actual days that he served, which were part of his original sentence, all candor to the court. Whether the court is going to allocate those towards the total days at this point.
Gotcha. So whether or not the 270-day sentence that was imposed in October included the 6 actual days that were credited on the original sentence.
Correct. If the court does not give the 6 days, he's at 209. If the court does give the 6 days, he's at 215.
I understand. You understand the argument?
Yes, I have no objection to the 6 days.
So the defendant would receive those 6 days that had previously been credited. So the 270 will give 6 actual credit days, so he has 55 more actual days to serve. Good luck to you, Mr. Romer.
Thank you, Your Honor.
I apologize, Your Honor. So it was 200 and what day, how many days that he was credited?
215, he's got to serve 270, so he's got 55 actual days to serve.
Okay, thank you, Your Honor.
It's 360. Yes, credit.
Yair Rico Rangel. Your Honor, this is a translator case.
Yeah, because of the translator, why don't we do that one later on when we need to get language line in for logistics purposes?
Okay. I know Attorney Mullins has been waiting with another translator case of a person.
And I see Gloria. Is Mr. Mullins here?
Yes.
Oh, Sean, sorry. And I see Ms. Lupo.
State calls Jose Eduardo Lopez Sia.
Sorry, Sean, I didn't see.
This is cause number 64 DO2 2508 F6 9203. State by Deputy Prosecutor Pavlovsky. Defendant, defense counsel, and interpreter appear in person. We are set for an omnibus hearing.
Got to get the computer straight first. All right. And so, Mr. Mullins, we're going to need Ms. Lopez to. Ms. Lopez, please raise your right hand. Oh, man, I didn't even see Sean. Gloria, do you swear to translate from English to Spanish and Spanish to English exactly as spoken? All right, thank you, Ms. Lupo. Sir, will you raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? What is your name? Can you understand the interpreter? If there's ever a time where you cannot understand the interpreter, will you let me know, please? How old are you? Are you a United States citizen? Of what country are you a citizen? And we're here for a change of plea, Mr. Mullins?
We are, Judge. May I approach?
You may.
Sorry. See you, Sean.
Sir, did you sign a plea agreement?
Yes.
Mr. Mullins, was that plea agreement translated into Spanish as well?
Judge, I had a translator with me in the office at the time we went through it, so yes.
Sir, did Ms. Lupo translate the written plea agreement to you? No.
It wasn't Miss Lupo, it was a family friend that
Sir, did someone translate the English in the plea agreement to Spanish for you?
Yes.
Do you understand the written plea agreement that you signed?
Yes.
Did anyone force you to sign the plea agreement?
No.
Do you understand that if I accept the agreement, I must sentence you the way that it's written?
Yes.
Do you also understand that if I accept the plea agreement, then that may result in your deportation to Mexico? Mr. Mullins, can you, in short segments, set forth the terms of the agreement?
yes, Judge. Judge, pursuant to the terms of the plea, Jose will enter a plea guilty to count 2. That would be operating a vehicle without ever having received a license. And that'd be a Class C misdemeanor. Pursuant to that plea, state will dismiss count 1, auto theft. And regarding his sentencing, it'd be 30 days Porter County Jail. That is suspended to be served on administrative probation with automatic expungement at the end of that 30-day sentence. And that would be the sum and substance of the agreement.
So, Mr. Mullins, my understanding of the plea is that plea to count 2, 30-day suspended sentence with an automatic expungement at the end of that 30-day sentence.
Correct.
Sir, is that your understanding of the plea agreement that you entered into?
Yes. Yes.
Factual basis, Mr. Mullins, just for count 2.
Jose, I'm going to ask you a couple questions. Jose, on August 17, 2025, were you operating a motor vehicle within the confines of Porter County, Indiana?
Yes.
And at that time, you did not have a valid license? And in fact, you've never received a valid license in the United States? So
I have not.
on that date, you were operating a vehicle without ever having received a license? Nothing further, Judge.
Is the state now moving to dismiss count 1?
So moved.
The state's motion to dismiss count 1 is granted. I enter judgment of conviction under count 2, operating a vehicle without having received a license, a Class C misdemeanor. The defendant is sentenced to 30 days in the Porter County Jail. all of which is suspended to administrative probation, that conviction will be automatically expunged at the end of a 30-day sentence. Good luck to you, sir.
Thank you, Judge.
Okay,
Yes,
all right.
no bond assignment. Back to the poster.
We are going fast forward because, hold on, let's just see. We're skipping some of this, guys. It's really, really, really
You want me to
bad.
call Wrangle next or still wait for,
We want to do Mr. Wrangle next.
okay.
All right. And what we're going to do with the jail, with language line, is we're going to try to call into the jail as well so that we can do it by phone with the defendant, with the language line interpreter. Do you understand?
Yes, Your Honor.
Like we did the other day. What's the jail number?
It is 219-477-3061.
Client solution. Please enter your 6-digit client ID. For Spanish, press 1. For other.
How come we can't hear language line? Can you hear us on language line? Is it dialing? Dose? Yeah. We can't communicate with the interpreter.
Still catch Gloria before she leaves the building.
If need be, we may need Gloria. Yeah.
Shall I?
Yeah. Or Officer Ball. Can you grab Gloria if we can't get language line?
The language line solution. Please enter your 6-digit client ID. For Spanish, press 1. For other, press. Reason is that ID 382201. Understood. Today I am 30.
All right. Can you hear me, this interpreter?
Yes, I can hear you.
All right. So this is the court, and we're going to need you to call into the jail as well, so that the inmate can hear you. So can you do that if I have you call in on a different line? We did this the other day. All right. So the jail phone number is 219-477-3061, but we're conducting part of it by Zoom, and we'll do part by phone to jail. So go ahead and call that number, please.
Yes, one moment.
All right. So, Madam Interpreter, please raise your right hand. Do you swear to interpret from Spanish to English and English to Spanish exactly as spoken?
Yes, I do.
All right. All right, so please call the case, Mr. Prosecutor.
Give me up there or?
Probably better up here.
I'm ready to mute, guys. I'm ready to mute. Don't worry. I
This
just
is
don't know who it is.
State of Indiana versus Yahir Rico Rangel.
Este caso es el estado de Indiana contra lo que es el señor Yankee y Courtroom.
This is cause number 64D02.
Esta causa número 64D02,
Dash 2511
2511,
dash F4
F4,
dash 12752.
12752.
The state of Indiana is present by Attorney Pavlovsky.
El estado de Indiana está presente a través de lo que es el abogado Pavlovsky.
The defendant appears remotely from the Porter County Jail.
El desfasado aparece de manera remota de lo que es la ciudad de Porter County.
And is present in court by Attorney Shargalov for initial hearing.
Y está presente en la corte con lo que es el abogado Shargalov para lo que es esta aparición inicial.
Sir, please raise your right hand.
Señor, por favor, levante su mano derecha.
What is your name? Oh,
¿Cuál es su nombre?
Yair Rico Rangel.
Yair Rico Rangel.
do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
¿Firma decir la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
You can put your hand down now, sir.
Ya puede poner su mano.
Can you understand the interpreter?
¿Debe ser el intérprete? Yes.
If there's ever a time where you cannot understand the interpreter or you can't hear, will you let me know, please?
Y exactamente si usted no puede entender al intérprete o no puede escuchar, por favor avísenme.
The prosecutor will advise you of the charges that have been filed in small segments.
Ya le va a avisar acerca de los cargos que están presentando en espacios o segmentos pequeños.
The state of Indiana is charging the defendant with 2 criminal counts.
El estado de Indiana le está presentando cargos a lo que es el acusado con lo que son 2 cargos criminales.
Count 1 is child.
Yep, that's him. I wish the worst possible. I wish every bad thing on that man sitting right there. Even though he's considered innocent until proven guilty, I hope he's deported. I hope they get him out of this country. I hope that he never, ever, ever, ever comes back here again. He's sick. This was like one of the worst cases I've ever sat through. I didn't. I sat through as much as it took for me to understand that this is horrific, this man. And we're not going to go through it. And what the thing is, I told you I'm working on some big things. So I know I've been slacking on my live streams. I know this, guys. I know. I'm doing my best, and it's only for a little bit longer. But last night when I got off work, I was like, I am going to listen to this. I'm going to see what's going to happen on my live stream so that we're not all surprised. So I did it. I sat through this docket last night, and this came up. If I would not have done that, if it would have been just yesterday that I played Claymore instead of today, you guys would not have recovered. Not recoverable. Sick fucking bastard. I hope he rots. Alright. Move on to the next guy.
This is State of Indiana versus Daily, cause numbers 64D02, 2502 F5 2132, 2503 F5 3085, and 2503 F5 3101. State by Deputy Prosecutor Pavlovsky, defendant and defense counsel appear in person for status.
Morning, Mr. Katsidimis.
Good morning, Your Honor.
What is the status?
Your Honor, we've received our paper discovery in this matter. There was also some additional electronic discovery that we've been provided. I've finally had an opportunity to review all of that information. I need to schedule time to meet with Mr. Pavlovsky to go over this matter. I do anticipate having an agreed resolution. Here, I'm asking for a new date. I was looking with the holidays coming up at January 14th, if that's convenient.
Any objection?
No, Your Honor.
Taking the rule 4 times.
Yes, Your Honor.
Defendant's motion to continue is granted. Any date previously entered is vacated. This matter is set for status January 14th at 10 o'clock. The delay is charged to the defendant. Mr. Daly, you are ordered to appear. Do you understand, sir?
Yes.
I will see you then.
Thank you, Your Honor.
Thank you, Mr. Katsidimis.
Ja'Cory Brown. This is State of Indiana versus Brown, cause number 64D02, 2403 F5 2558. State by Deputy Prosecutor Pavlovsky, defendant. Is he on Zoom? No. Fails to appear but is present by Attorney Shargolov, appearing on behalf of Attorney Brown. Okay.
Your Honor, again, Mr. Brown has typically appeared via Zoom. I've explained to the state, we have a meeting, there he is.
There he is.
Your Honor, Mr. Brown's case, just need one additional setting with to meet with the prosecutor. Barring any issues, we should be meeting on the 4th to discuss Mr. Brown's case. I'd ask the court for a setting, either early January, Judge, or December. I know this case is getting older. If we don't have a resolution, we can certainly get a trial setting at that point. We would accept the Rule 4 time.
No objection.
I hope they keep him alive, though. I just hope he suffers a lot.
Matter is set for a change of plea on January 7th at 9 o'clock. If a plea isn't entered at that point, I'll set it for jury trial, and in all likelihood, that trial will not be vacated.
Understood.
Mr. Brown, it might make sense. Do you live in Valparaiso still?
Nah, I'm
Where-
in Illinois. I'm currently on my probation officer for Illinois. That's why I didn't know that you called me.
All right.
But yeah, I'm in
So-
Illinois.
All right. You may attend the January 7th meeting once again by Zoom, sir. January 7th, 9 o'clock.
Okay, and can I ask a question, Your Honor?
You might, that may not be a good idea, but you can.
I was trying to ask about the agreement. I never received the agreement. Do I supposed to be?
Hold on.
Mr. Brown, office will be in contact with you, okay?
Okay.
All right. Thank you, sir.
That's what I told you before was not true. So I went through that. I fast forwarded it. I saw this guy, but that last guy took everything. I worked all day, and then I heard that, and then I was like, I'm done. So this is as far as I actually listened. So I don't know if something bad is coming up or not. Hopefully not. Hopefully we had enough of that.
Cortez Dillard. This is State of Indiana versus Dillard, cause number 64D02, 2509 F4 9930. State by Deputy Prosecutor Pavlovsky, defendant and defense counsel appear in person. We are set for omnibus hearing.
That's correct, Judge. I would just ask the court to roll the omnibus to the January 14th pretrial and affirm the jury trial of February 9th, 2026 at this point, please.
Those dates are affirmed. Mr. Dillard, you are ordered to appear as previously ordered. Do you understand that, sir?
Yes, sir.
I will see you in January.
Evan Morris. This is State of Indiana versus Morris, cause number 64D02, 2508 F5 8629, state by Deputy Prosecutor Pavlovsky. Defendant and defense counsel appear in person. We are set for status on an NCO.
That's correct, Judge. We filed a motion to terminate the no contact order in this case. May we approach, please?
May, and we will be in recess for about 5 minutes.
I hate fast forwarding on this piece of crap software. All right. See, it doesn't update the time. When you're playing a video, it tells you exactly what second you're at in the video. Well, this one just doesn't update it. So when I fast forward 5 minutes, I don't know how far that slider is 5 minutes.
Is Evan Morris.
This is good enough.
That's
guys.
correct, Your
I'm
Honor.
sorry.
We had
This is good
filed
enough.
a motion to terminate the no contact order, and the defense is prepared to proceed on that today.
You may.
Defense would first call Karen Sandberg. She's appearing via Zoom, Your Honor.
So Ms. Sandberg, you're muted right now. Please unmute yourself.
Okay, yes, sir.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do, sir.
What is your name?
Karen Sandberg.
All right, Mr. Chargoff.
Thank you. Ms. Sandberg, could you spell your last name for the court reporter, please?
Sandberg.
All right. And currently in this case, there is a no contact order that the court has put in place, correct?
Yes,
And is it your desire that that no contact order be terminated?
yes,
That you be allowed to have contact with Evan, correct?
yes, sir.
Are you currently in fear of Evan?
Absolutely not.
All right. And do you assist? We don't need to go into the details of this, Ms. Sandberg, but do you assist in providing some level of care and treatment for Evan?
Yes, sir.
Nothing further, Your Honor.
Any cross-examination, Ms. Sandberg?
Just briefly, Ms. Sandberg, you would admit that this is not the first incident of domestic battery with Mr. Morris, correct?
Yes,
And in fact, he did plead guilty to domestic battery in a case from April of last year. Are you aware of that?
yes, I am.
No further questions.
Without getting into the details, Mr. Chargoff has indicated that you, in some manner, provide care to Mr. Morris. Is that right?
Yes, sir.
And without getting into the details, because we're live streaming, you understand that there are certain things that should be done to assist in the care of Mr. Morris without specifically describing those publicly. Is that right?
Yes, sir.
Does anyone assist you in providing that care?
Yes, sir.
All right. And is it your belief that whatever has been recommended, that you will make sure that that care is provided as recommended?
Yes, sir.
All right. Your next witness, Mr. Chargoff.
Thank you. Defense would call Tiffany Sandberg, Your Honor. Walk around there. I have been up to the witness stand. Don't be seated just yet, okay? Judge
Walk
gonna swear
over
you.
here. Careful for the cords. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? What is your name?
Tiffany Sandberg.
Have a seat, please.
May I?
You may.
Thank you. Ms. Sandberg, would you spell your name, last name for the court reporter, please?
Sandberg.
And again, similar questions. You are the person who is protected by way of a no contact order in this case, correct?
Yes, ma'am.
And-
Yes, sir.
And is it your desire that the court terminate that no contact order at this point?
Yes,
All right. And are you in fear of Mr. Morris?
absolutely not.
Okay, and similarly to the question asked to Ms. Karen Sandberg, you're aware of some circumstances that require some additional care for Evan, correct?
I'm one of the caretakers.
So you are in fact aware.
Yes, sir.
Okay, and you assist Ms. Karen Sandberg in providing some of that care, correct?
Yes.
And is it your request again that the no contact order be terminated in this case?
Yes, please.
Nothing further, Judge.
State.
Ms. Sandberg, same question. You were also involved in the domestic battery charge that was filed against Mr. Morris last year, correct?
Yes, sir.
So this is not the first incident of
No, sir.
domestic type battery.
No, sir.
Okay, no further questions.
Has that closed caption been on the whole time? Because I didn't turn it on, and there's really no way for me to turn it on or off. This is grabbing a file from my computer. Like, I don't know where that came from. And I wasn't here when I recorded it. I was at work. So I didn't turn it on. I don't know what's going on. I know it's hard. If you don't use closed caption on your videos, it's hard to watch video with closed caption on because it keeps drawing your eyes away, and you keep flipping back and forth, back and forth, and it gets exhausting after a while. I don't know why. I saw haunted. Is I haunt you here? Karen, are you here? Anyway, I don't know why it just flipped on, but I can't turn it off.
So I guess I could have asked Karen Sandberg as well as Tiffany. Do both of you understand that if you ever feel threatened or endangered for any reason at all, you may dial 911, and in fact, you should dial 911. Karen Sandberg, do you understand that?
Yes, sir.
Tiffany Sandberg, do you understand that as well?
Yes, sir.
All right, you may step down. I am granting the motion to terminate the no contact order. And the witnesses who have testified have indicated that they will assist in Mr. Morris's care generically.
Judge, we would just ask the court then with the termination of that no contact order, affirm the pretrial for December 17th and affirm at this point the jury trial for January 26th. I know we have some conflicts on that date. We can deal with that on the 17th of December.
Those dates are affirmed.
Thank you, Judge.
I just get state's objection on the record.
I apologize, but yes, the state does object to terminating the no contact order based on the previous matters. The state's objections noted and overruled. The no contact order is now terminated.
We'll be in contact, Evan. Okay.
But Mr. Morris, you need to follow up with treatment and medications as your.
I need treatment and medication. Oh my God. Okay, let's pretend for a second somebody needed medicine that was very expensive. Not life or death. They're not going to die if they don't get this medicine. They're fine if they don't get this medicine, okay? But let's say they need some medicine and it costs $30,000 a month. Straight up, legitimately. Costs $30,000 a month, right? If that person were to become incarcerated, do they get that medicine in jail? Like, does the jail provide medicine that expensive? I have to know. How do I find this answer for real? How do I know for real? I mean, you guys are going to tell me an answer, but we have all been wrong before. We have all been wrong before today. 2 of us have broken toes today. If it's not life or death, Monica, like they're not gonna die, or even, I mean, I guess through time, if it's not taken care of over a long period of time. But I wonder, guys, on a scale of 1 to 10, 10 being impossible living conditions, 1 being you know, how bad is jail? How bad is prison? How bad is prison? Because I'm just wondering for a friend. I'm just wondering. how bad it is, really. Is it worth, if you were paid $30,000 a month to be in prison, would you go to prison for $30,000 a month? If you get house arrest, they don't pay for your medical, do they? I think you have to be incarcerated. I just wonder. I mean, I'm wondering. It's just a wonder. I'm just thinking out loud here. This is how we grow and learn. We wonder. I wonder if I can do this.
Told to do. Do you understand that? And you also need to behave. Do you understand that? You understand that if you don't behave, then bad things will happen. Do you understand that as well? All right. I'll see you in December.
Timothy Pettis. These are cause numbers 64 DO2, 2107 F5 6138, 2201 CM 776, 2203 CM 1842.
Listen, okay, here's why I'm thinking I might be okay. Okay, state approved meds is fine. Do they pay $30,000 a month meds? Are they state approved? How do I know? This is why I think I would be fine if I was in prison. All right? So generally, daily, almost every day of my entire life, I'm happy wherever I am. I'm happy. I find the joy in it. I find the jokes in it, no matter where I am. So I feel like I would be fine in prison. I would have, do you know how many jokes I would have for prison? That content just writes itself. And no, there wouldn't be streaming, T, but you know what there would be? You know what I see all the time when I watch anything, movies, live streams in prison? I see sleeping. I see a lot of sleeping. My coffee every morning is horrible. They get rheumatoid arthritis meds and they cost a boatload. And those are not life or death, right? But okay. I'm not a doctor or a nurse. And I understand if arthritis isn't managed as it could be, over time that could cause complications that could lead to death. But rheumatoid arthritis meds are not life or death medications, right? And you think that the prisons cover that, those types of medications? This is important stuff, guys. Guys, listen. I know how to get around this. I do. I have an idea. It's a great idea. It really is. Okay, are you ready? All of us, 100 of us, 100 vibers, go to the same city, commit a crime, go to the same jail. Then we don't have to worry about the gangs. We are the gang. Vibers. And in our gang, there's no fighting. Because I'll beat you. No. So if we all do this all together, we fill up our own prison. And they feed us. And they clothe us. And they let us watch TV 1 or 2 hours a week. This really can't fail. We would spend years just happy. Imagine just being happy for years. No one tells you how to do that when you're growing up in school, but I'm telling you now how to do it. All right, we got to get back to work.
And 2205
Never listen to my
F5
advice.
4483, State by Deputy Prosecutor Pavlovsky. Defendant fails to appear but is present by counsel. We are set for status.
Correct, Judge. I believe there's a new case. Mr. Pettis has an active warrant currently pending at this
Is
time.
he a criminal?
For the record, I'd ask the court to take the issuance of a bench warrant
Yes.
under advisement.
Kelly, that's the beauty. we would commit felonies. We would rob banks or something like that, casinos. That way, if we get caught, we get our goal. Is a big party in the jail. But if we don't get caught, we got the money. It's a win-win.
Good that you asked that. State.
I think I have to say I'm joking. I think I have to cover my butt here before I go to jail. For real? I'm joking. Please don't want nobody rob a bank and say, well, court vibes said we were robbing banks. No, the hell I didn't. I was joking. So just stop.
I would ask for the warrant to be issued at this time.
I will issue warrant for the defendant's arrest. My expectation is, whatever court has him arrested first will deal with that warrant first. I will issue warrant for the defendant's failure to appear.
Shannon Skiba. This is State of Indiana versus Skiba, cause number 64D02 2307 F4 6027. State by Deputy Prosecutor Pavlovsky.
She appears via Zoom.
Defendant appears via Zoom along with Attorney Shargloff, who appears in person. We are set for status.
Correct, Judge. We had orally requested last week, I believe, to reduce Ms. Skiba's level of pretrial supervision without getting into the details. They are medical in nature. That is the only basis for the request. I'm sure we can elicit some testimony from my client regarding the circumstances surrounding that. What I would affirm to the court is the information that we have at this point is that it's fairly intensive, Your Honor, requiring several appointments and follow-up appointments. And based on that, we're not asking that she be taken off pretrial supervision, just that the level of check-in be reduced, please. As it stands right now, in furtherance of the argument, I do not believe that a petition to revoke pretrial supervision has been filed in her case at this point.
Ever?
I'm looking at the docket, Judge, and I do not see one. Having been filed in F4 6027.
All right. Before I hear from the state, and I will let the state speak this time, I promise. I'm going to ask your client some questions. So Ms. Skiba, please raise your right hand.
Yep.
Do you swear or affirm the testimony you're about to give will be the truth and the whole truth and nothing but the truth?
I do.
What level of supervision are you on now?
I'm weekly, reporting weekly, every week, once a week.
Are you working somewhere now?
No, due to my health issues, I haven't been able to work for about 2 months. I actually had a procedure on Monday on my colon, and last week one on my heart, a stent in my heart. So it's hard from recovery. 2 weeks ago, I had another procedure on my colon.
All right. And we don't need you. You can stop right there. You with the first one.
So
Judge, if I may, hold
Sorry.
on, Shannon.
Okay.
If I may, we also, this is the case where Ms. Skiba is still attempting to get her DD 214. There was an address issue in that request that she made to the Department of Defense. She has since re-requested that it be sent to the right address. So initially, that's where we were considering heading in this case with Deputy Peterson. Once I have the DD 214 that Ms. Skiba is working to produce, I'll take that to Mr. Pavlovsky to discuss a disposition related to a DD 214.
Well, and what I recall from the last time, and I remember this because I've asked Ms. Skiba a number of times what branch she served in. She served in the Army, and I sort of suggested that she get a mentor from Veterans Court, even though she's not formally participating in Veterans Court. That mentors, especially from the same branch of service, are good. So are you being tested one time a week, Ms. Skiba?
when I'm able to report to probation, yes. When I'm not able from being, not my doctor not, giving my return date, I'm not able to return. I've turned in all my medical documentations, to probation, but I went a year and a half solid of testing weekly, just fine, up until these last maybe month from everything I've been going through with my health issues.
Okay,
Mr. Pomeroy, is this your case?
It is not.
Who's the pretrial supervisor?
Bear with me a second while I look. Thank you.
Ms. Skiba, who's your pretrial supervisor?
Erica D. Mass.
I don't think I see her on Zoom.
Your Honor,
I can grab her real quick if you'd like.
why don't you go ahead, Mr. Pomeroy?
Thank you, Your Honor.
Two. Violations, you know what I mean?
I'm her officer.
Hi, Erica. It's Attorney Pavlovsky. Just gonna ask you some questions about your pretrial supervision of Ms. Skiba. Is that okay?
Yes.
So how long has she been on pretrial with you?
Thank you,
Since
Kelly.
July
Thank you.
of 2024, I do believe.
Okay. And how often is she being drug tested?
She was ordered the once a week, and when she can report in, she is tested once a week.
Okay. So far, has she ever tested positive?
There was a positive test that we completed a violation matrix for, and that was
Jude wants to start a
1
cult.
second.
I'm in. Let's start a cult. Let's do it.
That was in August of this year.
What was the positive screen for?
It was for cocaine.
Okay.
And that's never been my,
Shannon, we're not
Sorry.
talking about that.
How many drug screens has she had since then?
Oh my God, who else just thought of Shannon Party in that? Remember that case with the crazy Karen and her husband who was a lawyer? Shannon? Shannon, not now. And she's screaming at the police and she's screaming at the judge and she's filming her neighbor running his truck, and he has a mental health lives matter sign pointing to her, and he has lights flooding her house. Do you remember Shannon Party? Shannon Party. She sued the entire homeowners association, and she sued all of her neighbors, and she sued the judges, and she sued the police officers. She sued her lawyers. Not her husband though. I think she got divorced from her husband though. You remember her? She's so good. He just said, Shannon, we're not getting into that now.
Since the first positive, only 2 because of all of the health and medical issues.
Other than the positive screen, were there any other violations of pretrial supervision?
No.
Okay. I have no further questions for Erica.
Did that, positive test result in an APM?
It was a violation matrix, which is basically pretrial's form of a APM.
All right.
Did my question lead to any follow-up, Mr. Chargloff?
No, Your Honor.
All right. Thank you, and thank you, Mr. Pomeroy, for helping out as well. All right, argument.
You're obviously the positive drug screen is a bit of a concern. That being said, she has been on pretrial supervision for quite some time. That appears to be the only violation. I'd like to see a couple more clean drug screens before a reduction. I would say if she gets in once or twice by the end of the year, maybe starting January, bump it down to pretrial level 2. But It's pretty recent, last positive drug screen, just
Yes.
what, 2, 3 months ago. So, that'd be the state's recommendation.
Mr. Charkloff.
I would just ask the court reduce it to
I
level
love little
2 at this
Debbie's.
point, Judge. It seems like in the what it's worth category, given the health concerns, it's basically level 2 at this point.
So without putting the cart before the horse, does the DD 214 factor into a resolution? And does that depend in part also on or Superior Court 6?
I think it would, Judge. Again, waiting to get that DD 214 to begin any application that was previously offered by Mr. Peterson. So I have to take that back to Mr. Pavlovsky.
At this point, I heard enough testimony regarding unrelated medical issues. I'm reducing Ms. Skiba's supervision to level 2. Get your DOD paperwork, Ms. Skiba. So based upon that,
Could we get a status in January, please, Judge?
this matter is set for a status January 14th at 9:00. Get the medical care you need, Ms. Skiba.
Thank you, Judge.
I am, thank you.
Daniel Supernet.
He's appearing via Zoom, Judge.
This is State of Indiana versus Supernet, cause number 64D02 2403 F3 2430. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely along with Attorney Shargoloff, who appears in person. We are set for status.
That's correct, Judge. There's currently an active warrant in Mr. Supernant's case. That was based upon allegations related to failure to comply with pretrial supervision related to inpatient treatment of Mr. Supernant. Obviously, he's not in court today. He is, however, appearing via Zoom and is at an inpatient treatment facility. What I would request, based on, again, the court's practice that I've seen, I'd request the court. May I ask Mr. Supernant a question?
In a second. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? As soon as you unmute, that would help as well.
Mute.
All
Yes,
right.
Your Honor.
What is your name?
Daniel Supernat?
Is there someone in the room with you?
Yes.
All right. So to the other person in the room, where are you right now?
Where am I right now?
No, I
We
want to
did-
hear from the other person.
We just left the.
Daniel, where's your caseworker?
She's not here right now. We just
Oh.
left. I'm going to an IOP. It's a inpatient.
She's not here right now because he's not where he's supposed to be.
All right, it's an intensive outpatient program. It's actually the main branch is it's in Terre Haute, Indiana. There's one closer to my house that's in Griffith. It's
So,
at
hold on. Where are you like right now? I see you're in a room. What room is that part of?
I'm currently at home right now.
I
I
thought
just
you were
left-
an inpatient.
I was correct. I was in Hickory. I just left. I'm gonna be going to an IOP program. I can't even say the name. It's Anna
Branch.
Yeah, Anna Branch.
So let me ask you this.
Yes.
When are you going to Anna Branch?
Well, I already applied for it today. It's a virtual and it's in person.
See if I can help you. Never learned.
I basically have like a learning disability. So can my wife speak on record?
No.
So, Judge, I apologize. I certainly was not attempting to mislead the court. He's indicated he was at Hickory.
Yes.
My understanding is that, Daniel, hold on. My understanding is that he has put himself at least into the queue for a subsequent inpatient treatment program. I would ask the court to allow me a week to get some documentation regarding that. Consider recalling that warrant at least for 1 week and have Mr. Supranant ordered to appear in person, so that we can figure out exactly what the plan is.
But if I'm gonna order him to appear in person, why don't I just have the sheriff go give him a ride right now? Or he could go to an inpatient place and stay. Because otherwise, he may be in the chemical dependency and addiction program. State.
I think we have a fourth addendum that has not been addressed yet.
And that was the basis for the start of my argument, Judge. The allegation is the leaving the inpatient facility without completing the program. So at this point, we would enter denial to the allegations, ask the court to again recall that warrant, give us a week to come up with some type of plan, and have Mr. Supranant here in person, have him tested in the interim.
Do you have a job, Mr. Supranant?
Yes, I do have a job.
Where do you work?
I work for 2 different companies, actually. I work for C&B Demolition and Excavating. Right now it's part-time because it's going into winter, but I also work for Need a Lift Towing, driving a tow truck, sir. And basically the reason why I left the first program.
Daniel, we're
Yes,
not
sir.
talking about why you left because we've denied the allegation at this point.
Okay.
The warrant stands. Mr. Supranant, though, and if he isn't arrested first, can turn himself in to the court next Wednesday at 9:00. And the warrant will be addressed at that point. Or sort of give some advantage, you either avoid the police or go get checked into an inpatient program, or we'll see you next Wednesday, and then the warrant will not be recalled, but it's not recalled now.
Understood. Daniel, call the office, please, later today.
Yes, sir. Thank you.
All right.
Thank you.
Thank you, Judge.
Yeah, I'm gonna jump around a little bit. I know there's some attorneys that have been waiting on Zoom for a while. Jeremiah Parker. This is State of Indiana versus Parker. Cause numbers 64D02, 2412 F2, 13081, 2410 F2, 11045, and 2406 CM 6386. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with attorney Jason Denny, who is also appearing remotely. We are set for status.
Morning, Mr. Denny. Yep, I see him. All right,
Okay.
Go ahead.
Judge, I was working on getting a drug court evaluation with Mr. Peterson throughout the duration. I recently learned from the state that that option is no longer available on these types of cases. So I do have a backup plea that calls for some executed time, followed by some community corrections, followed by some probation. But I am not prepared to file that today. Your Honor, although the executed time for the agreement that I have would be coming up soon. So would it be possible to reset this 1 week and potentially submit an agreement a week from today?
I have no objection.
There'll be a pro tem sitting next week, and but yes, the
Okay.
defendant's motion to continue is granted. This matter is set for a change of plea status November 26th at 10:00. Delay is charged to the defendant. What
Thank
time
you,
works
Judge.
best? What is 10 a good time, Mr. Denny?
Judge, 10:00 next, let's see, next Wednesday. Yes, 10 works.
All right, 10:00 next week. All right.
All right, thank you.
Jonathan Russo. This is State of Indiana versus Russo, cause numbers 64 DO2, 2508 F6, 8816, and 1302 FD 1418. State by Deputy Prosecutor Pavlovsky. Defendant, is he on Zoom, Shane?
Yes, he
In
is.
the bottom left.
Both attorney and defendant appear remotely. We are set for omnibus on the newer cause and initial hearing on the 2013 case.
So we're having an initial.
Your Honor, just
On the
getting
D?
the phone up to speed, when I was taking a look at the new case, I ran his name and noticed that there was a 2013 FD that I think there was an original arrest warrant for, maybe it expired, and it's just been sitting there for about a decade. So I don't think we've ever done anything on it, from what I can tell.
So, Mr. O'Donnell, were you aware of the FD case, the 2013 case as well?
I was, Judge. I did speak with Mr. Pavlovsky about this when we met on this case, so we are aware.
All right. Mr. Rosso, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is your name?
Jonathan Russo,
Mr. Russo, how old are you?
35.
Do you understand English?
Yes, sir.
Are you under the influence of any drug or alcohol?
No, sir.
Do you have any mental or emotional disability?
No, sir.
Mr. O'Donnell, have you gone over the charges in the 2013 case and do you waive formal reading?
I have gone over them, and yes, I do waive, Judge.
So now what do we need to, well, I'll enter a not guilty plea on the on the case that was filed on October 14 of 2012. A Class D felony theft case. I'm entering a not guilty plea. All right, so now what do we need to do in both cases? Mr. O'Donnell.
Judge, we are set on short cause 8816 for pretrial conference on January 14th and then jury trial on February 9th. Judge, I would move to vacate those dates at this point and possibly set both of them for an omnibus hearing, possibly on January 12th at 9 a.m. if that's available.
Yeah. Any objection? The defendant's motion to vacate the trial on all other dates is granted. This matter is set for a status January 12th at 9 o'clock. On defendant's motion, the delay is charged to the defendant. And that would be on both cases, Mr. Russo and Mr. O'Donnell.
Yes, Judge. Thank you.
The previously ordered dates are vacated. It's now set January 12th. I'll see you then.
Thank you, Your
Honor. Jonathan Newman. This is
Good
State of
morning,
Indiana
Your Honor.
versus Newman, cause.
We ran out of time for Newman. We just ran out of time. I feel like I just started this stream and it's over. So I did want to talk to you guys a little bit of housekeeping. Starting January, 2 things are gonna happen here at Court Vibes. That's a little different. I think my OJ stream is about to end. I mean, I don't know if it's going to end in January, but it is going to end soon. I think we're on video 371 out of 498, but they're not all 2-hour videos. So, we can get through, and we run the OJ stream at 1.25 speed because that's how we roll. So what I plan on doing, and I want to start this off by saying, you guys do not have to follow along. I don't want you guys to feel like you have to be there at every single hour that I choose to do something, because that's crazy. I plan on starting 2 nights a week, live streams at night. short, 45 minutes maximum. Night live streams. Sleep is important, guys. Please sleep. Don't feel like, oh gosh, I have to go here again, and she's posting videos. Blah, blah, blah. Just come when you want to come, and don't come when you don't want to come. It's perfectly fine. Mods as well. I'm talking to the mods as well. Live your lives, guys. Live your lives. I am perfectly okay. I love when you guys show up. You know I do. It's the best part of my day every day is you guys. But I got new judges that no one knows Judge Claymore. We've seen some huge cases from this judge. Crazy cases from this judge. No one else knows him. Judge Eric. Nobody knows Judge Eric. He is really good. Christofino is really good. Cutie Pie is really good. So I want to do just 2 nights a week, a night slot to try to, show everybody these new judges, because they watch Middleton and Webster and Simpson, who are so good, but they watch the same things every night. The same judges, the same cases from 7 different content creators. You know what I mean? So, if nobody shows up at the night streams, I'm fine. I don't care. 7 p.m. Eastern Standard Time, 8 p.m. Eastern Standard Time. You know what I mean? Just one right after dinner, before people go to bed. Just a short one. And you know, we're just gonna see how that goes. Now, I'm not gonna start that till like January, because I'm not going into that empty. I'm going to stack up some content now. That way I have good stuff ready for when I start that, and I'm not just out there. That's me. I'm the judge stalker. I love it. Kathy Ramirez. Okay. No, it's not too much for me. I could do a live stream every night. Along with these ones. And one during the day. Well, Kelly. I don't know. I don't know. We'll see how life is working right now, Kelly. How life is working. I have a great job. I really do. I love my job. But I got things working. I have other things planned. Things are going good and bad. Things are going exceptionally well and exceptionally bad at the same time right now. So, but the thing is just to keep going. Keep going. If it fails, it fails. But if it doesn't fail, that's great. I work every day. I'm a worker. I have 3 jobs right now. 3. So we're good. We're good. YouTube is one of them. Because I get paid. So I can call this a job. I get paid for this. I'm going to make $7 from this live stream. $7 is going to go right into my pocket. And then I'm going to do a live stream for OJ. OJ, I make $3. So it's a job. But yeah. Dude. You have great hair, Monica. Look at her hair. Oof. Oof. All right. I'm going to end this and start OJ. And then I will see you all later. I hope you guys have a great day. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.